はい、皆さん、こんにちは。米国特許セミナーパテントターミノロジーです。このシリーズでは、特許用語、表現などをできるだけわかりやすく解説しています。講師は米国特許弁護士であるブライアン・エプスタインさんです。お願いします。今回は、アブストラクトのまとめ方という、テーマで、見ていきたいと思います。では、早速ご解説いただきます。では、ブライアンさん、お願いします。
はい、ありがとう。皆さん、ようこそ。So our topic today is the abstract of the patent application. And, we all kind of know the basic guidelines for these abstracts. The MPEP sets out a few of them. They should be 150 words or less. It should be 15 lines or less. I think that's new within the time of my career. The abstract is supposed to include the novelty of the application, and it should not include legal phraseology, like the word means or said. On the topic of this legal phraseology, are there other words that your examiner might object to? And the answer is yes. I've seen examiners object to the word, the phrase configured to before. So I will sometimes take that out. And of course, these are just guidelines, right? It's possible that your examiner will accept an abstract of more than 150 words. They don't always check the abstract. And, the purpose of the abstract is to enable the patent office and the public generally to determine quickly from a cursory inspection the nature and gist of the technical disclosure. And the important part here is that, this abstract is not supposed to be an academic abstract, right? It's something that's relevant to patent law. And sometimes, this gets confused by inventors who have academic backgrounds. They think that your abstract is supposed to be like an abstract to a technical paper. And maybe that was true once upon a time. But under modern practice, our case law holds that the abstract can define the invention. This is a bit different than the title. We also have case law that says that the title cannot define the invention, right? So, if your accused infringer argues that, the title of your application is not what their product is called, that's something that that can be easily refuted. But if your abstract, talks about particular benefits or whatever of your invention, and your competitor's product doesn't produce those benefits, they have a potential argument there that that they don't infringe because they don't produce those same results. And so, and what we mean by defining the invention, right, is that the abstract can limit the claims beyond the actual scope, the literal scope of the claims, right? A jury or a judge could find that the claims are limited by, beneficial portion, beneficial results that are discussed in the abstract. And so our best practice then in modern times is to just copy claim 1 into the abstract, right? We don't want to limit claim 1 beyond its own scope. We'll have to take out legal phraseology like means or said. But that's not always easily done, right? What if we have a really long claim? お願いします。
はい。ここでは、アブストラクトの概要についてでした。アブストラクトは、学術論文などのアブストラクトとは、全く違う性格のもので、150ワード以内、15行以内、新規性のある記載を含んでいなければならない、 法律用語を含んではいけないなどの、ガイドライン、決まりがあると。そして、アブストラクト、発明を限定する可能性があると。で、そのためクレーム1をコピーすることが非常に多いということでした。はい。これについては次からさらに詳しく見ていきたいと思います。で、ブライアンさん、次お願いします。
はい。So, please don't read this slide. This is an example from an Apple application. I believe it's from Australia. And here they have copied claim 1 into an abstract. And we can see that this is an exceptionally long claim. It's 287 words. This would not be acceptable in the United States. At the bottom of the slide, you can see, I've made this annotated explanation of what's going on in this abstract. Basically, the idea is that, we've got some sort of tablet or something, and we can resize the relative dimensions of the applications. If the, this is probably an iPad. If the iPad is multitasking, when it's in landscape mode, right, when it's flat, you can see on the left side here, we've got figure 44A with application 1 taking up about 2/3 of the screen and application 2 taking up about 1/3. If we switch the iPad to portrait mode, we then lose these relative dimensions. Right now we're looking at application 1 in full screen. So when we rotate the tablet back to landscape mode, we return to the default relative dimensions. This allows resizing, and we lose that resizing when we switch back. And so our invention here is that when we switch back to landscape mode, we retain these resized dimensions, right? We keep application 1 at 2/3 and application 2 at 1/3, as opposed to them each taking up 50% of the screen. お願いします。
はい。ここでは Apple 社の、クレームをですね、例として、アブストラクトの例として紹介しています。クレームの内容は、おそらく iPad に関するもので、横向きにして、2つの画面を表示させた後に、縦向きに回転させると、この2つの画面のうち、少なくとも1つが表示されると。で、そこからさらに横向きに回転させると、最初に横向きだった時のこの2つの画面が、最初のそれぞれのサイズを保ったまま再び表示されるという内容になっています。はい。で、これを踏まえて、次の解説に進みたいと思います。で、ブライアンさん、次お願いします。
はい。So, we're a modern team. And, what happens if we take this claim and we put it into ChatGPT, for example, and we ask it to summarize? And this is what it gave us. This is about 97 words. This would be a seemingly reasonable abstract, right? Because it meets the size requirements. And if you read through it, you don't have to do it now. You can watch the replay of the video and pause it. If you read it, you'll find that it generally, ChatGPT does a decent job sometimes. And it generally makes sense compared to what the claim said on the previous slide. お願いします。
はい。ここでは、先ほどの Apple 社のクレームを、まず ChatGPT で要約したものを紹介しています。先ほどのクレームを150ワード以内で要約するようにと、ChatGPT に頼んだところ、記載のように97ワードで要約してきたものです。で、このアブストラクトにはいろいろな問題点がありまして、それについて次に解説いただきます。で、ブライアンさん、次お願いします。
はい。So, we wouldn't discuss that if it were exactly right. So what are the issues here? So what we've done is, we've got the color highlighting to kind of point out some issues in this ChatGPT summarized abstract. You can see that there's this blue underlining on certain phrases, like each at different sizes, the word accordingly, and then at the end of this abstract, the phrase provide a dynamic user experience on the touch-sensitive display. And none of these are required by the claim. It's, the two applications can be, and in fact are disclosed as being at the same size, at least initially. So shouldn't, it's actually a pretty strict limitation to say that they have to be different. The applications don't necessarily resize accordingly. And again, there's nothing about this dynamic user experience. I'm not saying it doesn't provide a dynamic user experience, but my point is that your competitor will argue that their product does not provide a dynamic user experience. That's the problem with these types of phrases. There's also portions that are missing. So, for example, there's this green portion at the top that says that the device rotates to a second orientation. In our abstract, in our original abstract, it says from a first orientation. There's also red underlining at the phrase displayed concurrently. And, in our original abstract, it says that, it's displayed in a particular orientation. And, the question then is, are these not new, right? There's supposed to be novelty here. These are things that are new in our invention. And so, there's going to be a question as to what, if the novelty is actually in this abstract. The fact that this is just 97 words, including this last sentence, strongly suggests that there's nothing else new in the claim, right? That, you've got an extra 50 words here to reach the suggested maximum of 150 words. And so, you could definitely say more about the claim. You could say more about the inventiveness. Pardon me. But failing to do that, suggests there's nothing else in the claim. And so, it's not just a question of, can we identify differences? It's also a question of, like, Brian, is anyone likely to notice this, right? And the answer is sure. Your competitor is paying attorneys hundreds of dollars an hour to look through your patent application to find all of the reasons that they don't infringe your patent. And I can guarantee you someone will look at the abstract and compare it very closely to your claim to determine whether there are any arguments available. Which brings me to my next question. Brian, is anyone likely to care? That's actually impossible to prove one way or another. That answer relates to the balance between non-infringement. Your competitor's currently unknown product, right? I don't know how, let's say Microsoft infringes this. I don't know what Microsoft's product looks like. I don't know how it differs, how it's the same. And, this balance is struck between non-infringement and invalidity. And in the context of invalidity, we're discussing typically unconsidered prior art. And I don't know what that prior art looks like. Obviously, this application is not filed in the US. I don't know what was applied against it. I don't know what would be applied against it, in litigation. But it is reckless to not care, right? It's reckless to say that we don't know, we don't care about non-infringement. We don't care about invalidity. We do care. I just can't answer these questions today about, how important is this abstract. Which brings me to my next point of, okay, maybe there are some issues here, but the beauty of AI according to some people, is how inexpensive it is, right? ChatGPT generated this abstract for pennies. And on the next slide, I'll show you, my own proposed abstract. And I didn't really time it effectively, but it probably costs about $20 of client time to draft that abstract. Okay, I mean, usually I don't do stuff hourly, but let's say I did. That means that ChatGPT is, 0.1% as expensive as my time. And so the question then to me is, Brian, what do you have to say about the cost savings, right? I mean, like, fine, but maybe it's not as good an abstract, but the cost savings are tremendous. And my reply to that would be that, you're going to spend more than $20 of, my time if you have to explain to your licensee or your competitor why this abstract doesn't limit your claim, right? If it's basically the same as your claim one, there's no argument about whether, whether your abstract limits your claim. If it does become an issue in a litigation, such as based on, these issues of, the abstract not including novelty or requiring additional features, that's going to cost hundreds to thousands to tens of thousands of dollars if this becomes an issue in a litigation. And so the real question is not, my time versus ChatGPT, but whether, my time's a more efficient use than the time during litigation. お願いします。
はい。ここではですね、チャット GPT によるアブストラクトの問題点について解説いただきました。まずこの、少し分かりにくいかもしれないんですけども、この青い下線部があって、ここはですね、クレーム1に記載されてないと。記載されてないことが記載されていると。はい。で、反対にこの緑の下線部。これはですね、クレーム1で非常に重要な箇所であるのに記載されていないと。はい、で次に赤い下線部ですね。これは画面の表示の向きが指定されていないという問題点があると。で、このようにこのチャット GPT によるアブストラクトというのは、特に訴訟上の様々な問題を起こす可能性があって、唯一チャット GPT のいいところというのは、コストが非常に安く済むと。ただそれだけだということでした。はい。では次に行きたいと思います。ブライアンさんでは次お願いします。
はい。So here's my proposed abstract. Again, you don't need to read it right now. It's basically just the last four elements of claim one, and it's about 147 words. And so the question, is, if it's only the last four elements of claim one, then this does not include all of the potentially novel elements of claim one, right? Claim one was very long. And so the question that the audience should be asking me is, Brian, why is this abstract any better? Well, first, all abstract features are included in the claim, right? The abstract cannot limit the claims here. Second, although there are missing features, it would be impossible to fit all of our claim elements into 150 words, right? That's the guideline maximum. And so if you say, Brian, you're going to take the stand at our litigation trial and opposing counsel is going to question you as to, why you left out certain features, I think there's a legitimate argument that additional novel features could not be included, right? I only had 3 more words here. This is a very different case than the ChatGPT example of only 97 words. And in fact, if you take out that last sentence, that's purely about the advantage, the dynamic user interface or something, then it only takes up 83 words, right? So there's plenty of room for additional features there. It looks like a conscious decision to exclude things from the scope of your abstract. And if you're a savvy ChatGPT user, you're going to say, Brian, fine. You've made your point, but I'm going to just tell you ChatGPT to use exactly 150 words, right? it understands that instruction. So what's the difference now? So I tried that experiment, and I reached a result that's very similar to, but lengthier than the text on the previous slide. Okay. ChatGPT still included features that are not required by the claims. ChatGPT still left out details that might be considered new. And I don't just mean, could be considered new. I mean that I, as a human, that I, as a patent attorney, that has read enough of the application to understand this invention, these are meaningful features that it's leaving out. And, such a preparation, right, by saying that it must be exactly 150 words, certainly lessens the effectiveness of our arguments about admitting some claim features are not new, right? Again, if I can use the excuse that not all claim features would fit in 150 words, then the ChatGPT user can also use that argument. But the primary difference is that there's still no human supervision as to which features are left out. So even though one of the supporting arguments that I'm making is weakened for using a human prepared abstract compared to this ChatGPT one, the fundamental issues remain, right? It still excludes novelty from the claim in the abstract. It still includes extra features that are not in the claim into the abstract. And you're still going to, if you're a cautious litigation or licensing minded applicant, you're still going to require some human supervision to make sure that, ChatGPT is not making a mistake. And at that point, I think it's a better use of time maybe to just have somebody figure out the last few elements of the claim and you put that into the abstract. お願いします。
はい。ここではですね、ブライアンさんによるアブストラクトを紹介しました。全部で147ワードで、ここではクレーム1の最後の4つのステップのみを記載したアブストラクトになっています。で、これでも、クレーム1の、新規性のある部分をすべて記載しているわけではないんですけども、150ワード以内という制約の中で特に重要と思われる部分を、選んで記載したということでした。で、チャット GPT はこのようにどこに新規性があるのか、どれが重要かということは判断はできないだろうと。これは人間の専門家に依頼した方がいいだろうということでした。はい、今回はアブストラクトのまとめ方について解説いただきました。今回はこれで以上になります。ご質問や扱ってほしいトピックなどがありましたら、YouTube のコメント欄に書いていただくか、スライド最後に記載のメールアドレスまでお気軽にご連絡ください。では本日もありがとうございました。失礼します。
ありがとうございました。